Good morning again. Hello, my name is Amanda Callahan. I'm the coordinator for Counselor Connect. We appreciate you all joining us today this is our second session in our Spotlight on Legal series. So we are really thrilled to have two presenters with us today. We have Amy Fox and Caroline Wood. They are both from Church, Hittle, and Antrim attorneys at law. And I'm sure they'll do a little more introduction of themselves as well. As you can see on the slide, there is the bit.ly for the slide deck. I also put that into the chat so you can follow along with our slides. As we get into the actual content, you will see that this slide deck is different from that one. So just be sure to link into those slides as our two presenters begin. And then I'm going to switch over to a different slide deck here. Okay. And then I think we're good. Can you both see your slide now? Okay, yes. Perfect. Okay, I'm going to go ahead and kick it over to you both, and you can get us going.
All right, great. My name is Caroline Wood, and like Amanda said, I'm an attorney with Church, Hittle, and Antrim. I'm here with Amy Fox. We're both excited to be here. She's also an attorney with CCHA. Today, if we want to go to the next slide. Oh. Thanks, Amanda. Oh, well, there's our contact information. Should you have any questions that we're not able to answer throughout the presentation today, please don't hesitate to contact either of us. And just to take you through our agenda. So today we're going to talk about parent permission for counseling assessments. We're going to talk about child find, both a little bit under Section 504, although we know that our colleague Jessie Billingsley talked about that with you a little bit last time, but also under Article 7. Eligibility red flags, what to look for, what happens when we fail to identify students, some case law that's relevant to you all in your positions as school counselors, social workers, and then what happens when parents don't get on board. And then, of course, we'll end with some practical tips and takeaways. You can. All right, and throughout, we are going to look for the holiday movie slides. That's going to tell Amy and I first when we know to transition to the other person, but also something fun for us to see and talk about. So this is the top 10 holiday movies according to IndieWire. And Amy and I were talking about this before the presentation, and we are not sure how Elf is ranked number 10 because that would be a lot higher on our list. But nonetheless, Elf. All right, and we'll let Amy take it away.
All right. Thank you, Amanda. We're happy to be here today. And as Caroline mentioned, and Amanda too, I'm an attorney also at Church, Hittle, Antrim. And I have to tell you, my law career started at a seminar, probably similar to this. Certainly it wasn't web-based because this was in the late 90s, but at a seminar for school counselors on Section 504. I was a high school counselor at New Prairie High School in the late 90s and was interested in Section 504 and all the things that I was learning, and then decided to go to law school. And so I've been practicing school law kind of ever since. So happy to share with you, have a lot of respect and admiration for the hard work that you do, which I know is a lot harder today than it was back when I did it. So we're going to start and talk a little bit first about kind of HEA 1447 and some of the statutes that govern analyses, evaluations, and surveys. And I'm just going to refer to it as surveys because that's too much of a mouthful for me. So, but I want to give you, there are really two statutes at play here. And I think before we get to HEA 1447, I want to give you a little bit of background on the other statute that's relevant here. And this is a statute that's been in place since, I think, 2005. It's been modified a couple times since then, but this is the statute. When you'll see it here on your screen, the first one, IC 20-30-5-17. And we'll talk about sort of what's included in that. But if a survey fits within the definition in that statute, written consent is going to be required. It will be required from a student if the student is an adult or if the student is an emancipated minor. Otherwise, the consent is going to be required in writing from the student's parent. So I'm referring to that as kind of the opt-in, right? Because you can't give the survey unless you receive that written consent. And then the second statutory framework is HEA 1447. And in this, it sets up this opportunity for you to provide and implement a survey, even if you don't receive that written consent. However, there are a number of things that have to be done before that, and we'll talk about those things in terms of notice that have to be provided before you implement. Okay. So let's talk first about the older statute, right? The 20-30-5-17. And this is going to apply to a survey that is not directly related to academic instruction. Okay, so that's really a big limiting feature right there, and something you're always going to want to keep in mind. That reveals or attempts to affect the student's attitudes, habits, traits, opinions, beliefs, or feelings. So we've got these really broad words here concerning any one of these 8 categories: political affiliations, religious beliefs or practices, mental or psychological conditions that may embarrass the student or the student's family. Right, that's really broad, and who knows sort of what might embarrass one student might not embarrass another student, so it's going to be difficult to anticipate. Sexual behavior or attitudes, illegal, antisocial, self-incriminating, or demeaning behavior, critical appraisals of other individuals with whom the student has a close family relationship. Do you feel as if your parents don't support you? Right, that kind of a question, again, super broad. A legally recognized privilege or confidential relationship, including a relation with a lawyer, minister, or physician. So any kind of some survey that might elicit medical information would fit into this category, or income. So this is the category of surveys that this would apply to. So very, very broad. And if this is a survey sort of that fits within these frameworks, these requirements, the things that are required by statute are, one, as I mentioned, there has to be written consent. The consent form must accurately reflect the contents and nature of the survey. So there has to be a description of what's being asked so that there is that notification that's been given. The survey has to be made available for inspection to parents. Very often schools will post those on the website. That's a way to do it. But just making it available for inspection is really all that's required under this statute. And the school must notify the parents of their rights under the statute. Typically, that's accomplished through a board policy. And we've assisted a lot of school districts in drafting or revising their policies on this to make sure that they are alerting parents to what those rights are. And then the school must enforce the statute through policy. And often that's accomplished through a grievance procedure, which can be built into, either can be built directly into the policy on analyses, surveys, and evaluations, or it can be a separate grievance procedure. So we're going to shift gears now. That was kind of the nutshell version of the older statute, the one that's been in place for a long time. We'll shift gears. We'll talk a little bit about the new statute that was adopted by the General Assembly just last year in 2023, HEA 1447. And it applies when a qualified school, and that's going to apply to just about any school in Indiana, right? It's going to be any school within a public school corporation. It's going to be the school for the deaf, the school for let's see, Burris Academy, right? Sort of a laboratory school. It's going to be a charter school. So it's a broad definition of school that uses a third-party vendor. This statute some believe was targeted to Panorama, right? Panorama is a third-party vendor that provides a lot of surveys to school districts. So that's certainly one example, not the only example, to provide a survey that reveals, identifies, collects, maintains, or attempts to affect, right? So there are even sort of more words here, right? So it's even broader than the older statute, right? So now we're talking about if it identifies, collects, or maintains information about a student's attitudes, habits, traits, opinions, beliefs, or feelings. And here we don't even have sort of the 8 different categories of topics. However, sort of the limiting feature with this one is the use of a third-party vendor, right? So what's included in this statute is not going to apply to the circumstance where you have an in-house counselor or any kind of in-house school professional who is putting out a survey internally. The requirements we're going to talk about notice, et cetera, would not apply in that instance. There are a couple exemptions that we want to talk about, and these are instances in which the requirements of HEA 1447 just don't apply at all, right? I mentioned one of the big ones that's not specifically spelled out in statute, but it's in there about sort of a school employee promulgated survey, right? That's the big kind of exemption too. But academic assessments or tests, right, things that are administered in class, certainly that's going to be exempt. And so there are not going to be the notice requirements for those. Career aptitude or career interest surveys. And, those may be surveys that are related to employability skills, surveys that ask about a student's soft skills, right? Sort of those are not going to be subject to the requirements of this statute. There are a couple others. Assessments or screening instruments that are administered by a third party in one of these mental health professional positions, right? A psychologist who's licensed, or a social worker, clinical social worker, marriage and family therapist, or a mental health counselor who's licensed, who was referred by the school personnel in a crisis situation. If both the school personnel and the third party provider who's going to administer the survey reasonably believe that the student is in immediate danger of self-harm or harming another person, or experiencing harm that may be the result of abuse or neglect. Okay, so that's an instance where you don't obviously, and it's kind of a common sense exception too, right? Because these are kind of imminent situation where you want to make sure that you're being able to administer some kind of, or the professional, whoever professional it is going to be able to administer some kind of a threat assessment, and you don't need to sort of go through those notice requirements in that instance. And then the last exemption would be surveys or evaluations administered by a third-party vendor. So this could be something that's even administered by an outside vendor that attempt to gauge student satisfaction with the school's programming, technology platforms, or approved curriculum, right? So this is going to be kind of the student satisfaction, student engagement type survey. Okay, so those exemptions are kind of important to keep in mind. So this slide addresses what the notice requirements are, right? The statute specifically says that if you do have one of these surveys that that's not exempt, so you've got a third-party vendor who is wanting to provide, you want the third-party vendor to provide this survey, you have to go through this process before you administer it to the students. You have to send this initial request for consent, and it has to be provided in writing to the parent or to the student, if the student is an adult or an emancipated minor, at least 31 days before administration. Now, in practice, I think it's going to have to be a lot more than 31 days. I would say probably more like 60 days when you sort of look at kind of the other requirements here. So you send the first notice. If you don't get any kind of a response, ideally, you'll get a response saying, I consent for my child to participate. If you don't get that response, then you send a second notice, which mirrors the first, really. You have to send that within 21 days of receiving the initial request. If you don't receive a response within that time period, then you send a second request, which is identical to the first. And then both requests for consent have to summarize the contents and nature of the survey that'll be provided. Let the parent know that the student has the right to review or inspect all the materials related to the survey. Include the reasons that the school is administering the personal analysis or survey, right? So we want to improve student behavior, we want to improve communication, whatever the goal is of that. And then make sure that it includes an option to consent or decline. And then the next step, so let's say if there's still no response, then if after 10 days there is no response, then you can go ahead and administer the survey, or you can have the third-party vendor administer the survey if there is no response. Certainly if they respond and they refuse to consent, they decline to consent, you cannot administer the survey, but if you receive no response, then you can. Both requests may be sent in an electronic format. I know that, Panorama has got a lot of resources, and I'm sure sort of, other third-party vendors do have a lot of resources in terms of form letters and helping to develop a calendar to set this up to make sure that they're in compliance. So some of the other requirements are schools have to post a copy of any survey on the website, if this is something that you're going to do, and if it's a survey that fits within HEA 1447. And then schools have to give parents and students the notice of their rights. Again, this is typically done through a policy. Schools must establish and maintain the grievance procedure for the resolution of complaints regarding, an alleged violation of the statute's requirements. It has to be, the grievance has to indicate that complaints are processed in a timely manner, and then also has to identify kind of how complaints are submitted. And I know Caroline and I have both helped a number of districts kind of with developing those procedures and modifying the policies. And this next requirement on the slide, this is one of the big ones, which both the school and the vendor are prohibited from recording, collecting, maintaining responses or results in a way that would identify the response or results of a specific student. So essentially it's de-identified data, right? So this is if your vendor is administering the survey, all data has to be de-identified. And that really, those are the FERPA issues too, to make sure that we're complying with our obligations under FERPA. And then the caveat here is, right, the restriction doesn't apply if the survey is administered or provided by school personnel without a third-party vendor's assistance, right? So this is similar to what I had mentioned before. And then another requirement by statute is that all contracts between schools and third-party vendors for the administration of any of these surveys have to include provisions stating that if vendors don't comply with all of the requirements, the vendor has committed a breach of contract, right? So the vendors have a strong incentive to make sure that they're complying. And so, which is part of the reasons of why they've developed sort of really robust procedures and best practices and, all sorts of great ideas to help ensure compliance with that. So I encourage you to look at that. And then I think, just kind of in a nutshell, some of the takeaways on this. If you are contemplating administering a survey, or if you're approached about administering a survey, consult your board policy. Make sure you're familiar with your board policy. If for some reason you don't have a board policy, that's one of the things where you want to sort of wave the flag and say something to, administrator, look, I think we really need to have a board policy on this, because you do. And then one of the big questions that you want to ask is the survey unrelated to academic instruction? And does it relate to one of those 8 categories in the older statute, 2030-517, right? And if that's the case, then you know that you've got to have written consent one way or the other before any survey is administered. And then if that doesn't apply, then you look at, is there another exemption that might apply? Because then you're looking at sort of the HEA 1447 type survey. Is it a career aptitude or interest test? Is it academic? Is there a crisis, right? And everybody has this reasonable belief that their child may be experiencing harm or likely to perpetrate harm on others or subjected to some kind of abuse, right? That's a situation where you're exempt from those requirements. Is it a student satisfaction or engagement survey? Or is it administered by school staff, right? Those are the instances where you really don't need to worry about HEA 1447. But you do always want to make sure that you're checking your board policy, because occasionally boards will enact policy that's even more rigorous than what's in state statute. And then, once you've kind of cleared those hurdles, then I think the next step is make sure you sort of develop a plan, calendar all the dates, make sure you're involving others. Consider whether you seek board approval before administering it. There's a lot to be said for getting that kind of buy-in and support. And then, when in doubt, always err on the side of caution before administering a survey if you're not sure, particularly given some of the broad language that's frankly in both statutes about sort of questions about beliefs and then seek guidance. So if you can certainly seek guidance internally, but also from legal counsel too.
Amy, can I ask for a clarification before you move on?
Absolutely.
With the third party, if it's a third party assessment, let's say it's Panorama, just as an example.
Yep.
It's their survey, but the school administers the survey. So in that scenario, the HEA 1447 does apply because there's any collaboration with a third party, right?
It does not, it would not apply. Yep. If
It would not apply.
No.
Okay.
No. Yeah. So that's interesting. There is some Department of Ed guidance that suggests that if the third party generated the instrument and is essentially giving it to the school to implement, administer, process, kind of do all the analysis of the data that's yielded from that's not a situation where it would apply. Yeah.
Okay. I just wanted to seek that clarification before we moved on. So thank you for that.
Yep. Are there, oh, I see a question.
Yep.
So 10 states an exemption is for assessment of screening instruments. Would school counselors be able to administer the assessments on screening instruments? Oh, is that I'm thinking that's probably the crisis situation. I think, yes, right? I think that's an instance where a school counselor, could administer it without going through the process in 1447. So hopefully that answers your question, Julie. Let me know if it doesn't. So our number 9 movie is Gremlins, an old one from 1984. So I can barely remember it. I think I saw it when it came out, but I'll have to refresh my memory on that one.
I have never seen it. All right. So moving on, we're gonna transition now to child find. So if we can move to the next slide, please, Amanda. One of our goals as school law attorneys is obviously to protect schools from legal claims, and that includes these child fine violations. So we know that you all are student services professionals, so we really want to spend most of our time today talking about red flags that you might see in your roles. But first, generally, what is child find? So it's the affirmative, ongoing obligation that affects all school staff. And both Indiana and federal law require public schools to identify, locate, and provide special education services to children ages 3 to 22 within district boundaries. So we're going to break that down here soon. But the purpose, if we just slow down here, the purpose of the mandate is to ensure that students get the supports they need. And the law assumes that all adults in schools will recognize and take action to address the students' disabilities. So this is just a visual to show at what point students' procedural safeguards are triggered. And so we're going to be talking about the Section 504 and IEPs today. And then this is another good visual that for our purposes today, we just want to focus on seeing here that both Article 7, which gives us the special education IEPs, and Section 504 regulations have this child fine mandate. All right, so breaking down child fine under IDEA and Article 7. So one of the requirements here is that schools establish, maintain, and implement written procedures that ensure the location, the identification, and the evaluation of all students ages 3 to 22 who are in need of special education services. And on our next slide, we're going to see who's included in those students. So this includes students who have legal settlement, who attend a non-public school within the district boundaries, homeless students, wards of the state, students who live in an institution that's located within the district boundaries, migrant students, and then students who are suspected of needing special ed, even though they are advancing from grade to grade. And as you can see from our arrow there, oh, actually, unfortunately, you can't see on our version that's presented, but that is the most litigated. We have an arrow on another version of our presentation that points to that bottom right box that shows that's the most litigated area for child fine violations, is where the students are advancing from grade to grade. Oh, there it is. Thanks. And then moving on, this is just the language in the Section 504 regs that show that there's also the child fine mandate there, that schools have to identify and locate every qualified handicapped person and take appropriate steps to notify parents of their duty under this. Breaking down the legal language, schools are the experts, I think, is the big takeaway. The law assumes that educators are the experts in noticing if a child has a disability and how to go about evaluating that child, not the parents. So this quote here about parents never asked for an evaluation, so we never did one. That wouldn't fly in court. A parent request for an evaluation is not needed to trigger schools Article 7 or Section 504 child fine obligations. So regardless of whether a parent or a teacher makes a referral for special education, schools have this child fine mandate. Schools also have to have written policies and procedures in effect to ensure that all students with disabilities will be identified, located, and evaluated. So where are your procedures? What do they include? Have we read them? Moving on, those child fine procedures. So often we see this communicated to parents through a disclaimer on the district website, putting students on notice in the student handbooks, notice in PTO guidance. Ultimately, the existence of these procedures are less litigated than the red flags that we're going to spend most of our time talking about today. But we do want to make sure that school staff know where to point parents to in the event they're asked about evaluations or Article 7 or Section 504 obligations, or how to initiate a referral for an evaluation. So this slide shows that this process is really also intended to protect schools. So we can see what happens on both angles here. If we under-identify students, then we're not able to expel dangerous students, and we risk due process hearings for failure to evaluate. And if we over-identify, then there's disproportionality concerns. There's more burden on school psychs and staff. There is a balance here. So we're not saying that every student needs identified and evaluated, but we are saying that there's a process to protect you and your staff. And then this is another movie that I've not seen, White Christmas from 1954, but it is ranked number 8. So I'll have to add it to my list. And then Amy is going to talk about failure to identify.
Yep. I'm going to talk just kind of briefly about what are the consequences and why does this matter? I mean, and I guess the most obvious and most important sort of reason that it matters, is that, if there's a child who potentially needs services and doesn't get them, right? And that's sort of ethically and morally kind of the most important reason. But then, there are also sort of legal implications too. Caroline and I both, I know, have had this year, and this is one of the most frequently litigated areas, is eligibility issues, and sometimes really difficult to defend too, right? It happens when a parent has a child who is struggling, may result sort of after kind of some kind of an expulsion. Maybe there's been a lot of behavior issues that culminates in expulsion, or if, just kind of failure to progress academically after a while, will bring an Article 7 complaint against the school district, alleging that the school should have identified the child as a child with a disability under IDEA. Sometimes they'll file a complaint with the Office for Civil Rights, saying that the child is a child with a disability under Section 504, but most typically we see these as IDEA type complaints. And in the complaint, they're alleging that, look, my child should have been identified maybe a year ago, and so therefore my child's entitled to compensatory services for that whole period of time, the time period from which the school district suspected or should have suspected that the child had a disability, and the time that I've brought this lawsuit, or the time that the lawsuit is actually settled. Sometimes parents will withdraw the student from public school and place the child in a private school and then ask for reimbursement. So that can get really costly. If they bring an IDEA challenge through a due process hearing, the parent is entitled to their attorney's fees, and that can get costly. And these IDEA hearings they're like mini trials, and they happen, very quickly, and so can be costly and exhausting and a real pain in the neck for school districts too. So that's one of the reasons sort of why you want to avoid it. But as I mentioned, sort of I think the moral and ethical issue of making sure that children get sort of the services they need is certainly the most important. I'm going to shift gears and talk a little bit about some of the red flags. So there are some easy red flags. There are also some red flags that are harder to detect. So sometimes a parent will say something. A parent will say, look, I have an outside diagnosis of anxiety, depression. My child has outside diagnosis of anxiety, depression, ADHD. I think my child might need an IEP, right? That's something where you're going to want to respond one way or the other. Doesn't necessarily mean that you need to do an evaluation, but you're going to want to respond. Discipline problems, right? As I mentioned, if there are multiple suspensions or, and a recommendation for an expulsion even, and especially if there's a lot of aggression, physical aggression, that might be an indication, especially kind of if it's a younger child, that's a red flag. If HEA isn't working, right? If you're implementing kind of the MTSS or sort of whatever supports are being implemented in the general education program, and you're not seeing the progress, that's another red flag. If you're considering retention, or if a student is considering dropping out, that could be something too. A diagnosis we see this a lot, right? A parent will come in with a diagnosis of ADD, ADHD. That will be, and then again, doesn't always mean that the child is going to be eligible under IDEA, but it does mean sort of that the school district needs to do something and needs to respond in writing to the parent. And there are a couple, I'm going to shift to the frequently missed red flags. And I think these are the ones that you may be sort of the first line to hear about, right? A student who is having suicidal ideations, or if a student is hospitalized for mental health, that's an indication that perhaps the student needs, there may be some kind of a mental health disability, qualifying disability. And so maybe there are some services that need to be provided, or an evaluation that needs to be conducted. A lot of times, if a student is doing well, people will say, look, this child is very bright, and so therefore doesn't need an IEP. But that's not always necessarily the case. And I think, this is sort of the student who is doing well in school is one of the circumstances that's a frequently missed red flag. Chronic health conditions, asthma, allergies, right? That's one too, where I think the Office for Civil Rights is going to say a child in most instances will need a Section 504 plan too, if a chronic health condition like that. Sometimes if a student returns to school after having a serious illness or an accident, there may be a disabling condition that goes along with that. And so, that's a circumstance where a 504 plan might be necessary. Sometimes if a child is evaluated under IDEA and found not to be eligible, it's important too to do the analysis to look at whether or not a 504 plan is appropriate. Maybe there's not a disability that fits in one of the 13 categories under IDEA, but maybe it's still a disability, and maybe a 504 plan is going to be appropriate for that student. So that's another analysis that should be conducted. And I talked a little bit before about sort of the gifted students, the students who are doing really well. those are often sort of the missed circumstances. As I mentioned, kind of the triggering event, right, for sort of when the school is going to be on notice of sort of a child find, and the child find obligation is triggered, is anytime the district suspects or should have suspected a disability. So, what facts support a suspected disability? So we'll talk first about, there are instances in which there really is no disability, right? Not every time a parent asks for an evaluation, and not every time a parent comes in with an outside diagnosis do we have to do an evaluation, and is our obligation, child find obligation, triggered. It's not the case. However, every time that happens, we do have to respond in writing. We've got to do the internal review to look at, all these different factors. How is the child doing? Is the child making progress academically? What does that look like? Sort of taking into account all that information, and then responding to the parent in writing with sort of what's referred to in Article 7 as the prior written notice, explaining why it's refusing an evaluation at this time, and sort of listing the reasons for that refusal. Okay, so that's sort of the triggering event, and then there has to be some kind of a response. Bad Santa, number 7, is in our list of top 10 holiday movies, which is one I have not seen yet. And then another one I've not seen yet is Meet Me in St. Louis, number 6, from 1944. Okay, Caroline.
All right.
So we'll talk a little bit about some cases.
Yes. So Amy asked just a few minutes ago, what facts support a suspected disability? So the case law is really where we find those facts. So first, an attempted suicide might. So this is a case involving a DC charter school. It's an older case, so 2016, but looking at the facts of this case. So in January of 2014, a school evaluated a 6-year-old student under IDEA and found him ineligible for special education, but provided him a Section 504 plan. A couple months later, the student attempted to jump out the window and inform staff members that he, quote, wanted to die. Then within that same spring semester, it looks like March to May, he was suspended 6 times and expelled 4 times for disciplinary incidents that were normally involving physical aggression or assault of teachers and other students. In this case, the court found the district liable for a child find violation. So the court said that the school should have reconsidered the student's need for services in light of new information. So even though in January, the school evaluated him and found him ineligible after the attempted suicide in March, and then the increase in discipline in March to May, like Amy said earlier, that's a red flag where the court said that there was a child find violation and they should have reevaluated. Moving on, what other facts support a suspected disability? Bullying might. So this is a case where a 7th grade student went from earning A's and B's to C's. She lost over 30 pounds. In 8th grade, she began cutting. She received outside diagnosis from a therapist with anxiety, depression, anorexia, and teachers noticed changes too in her demeanor and reported concerns to the district. The parent informed the school of those diagnoses, and the parent actually signed, in this case, a permission for the school to evaluate in December of 2014. Unfortunately, in February, just a couple months later, after they got the signed permission for the evaluation, she was found dead by apparent suicide. And the parents brought multiple claims against the school under Section 504, Title IX, IDEA, and the court, it was a Pennsylvania district court, said that that the school district failed to evaluate despite having knowledge of the bullying allegations. And then this is another case involving bullying. This is an OCR case. So in this case, a student had ADHD and a Section 504 plan. Student had autism. The student was harassed, but there wasn't sufficient evidence that that harassment was based on the student's disability. The school investigated for bullying and said that bullying was occurring. And in this case, OCR said the student Section 504 team should have met to determine whether a change in services was warranted after the bullying was substantiated. So these are cases where the school had knowledge that the student was being bullied. Both of these cases are that, but if the school didn't have knowledge of bullying, it's unlikely that a court would find a child fine violation. And then self-harm. So what other facts might support a suspected disability? Excuse me. So in this case, in early 2013, teachers were noting failing grades and missing assignments. The student wasn't wanting to do any of their work. They were absent. In September, the student was admitted to a 30-day inpatient residential program due to mental health concerns, self-harming behaviors. The parents notified the district of the student's hospitalization and requested a homebound instruction. Then in November, the student was readmitted to an inpatient program. The self-harming continued, and the district said it sent home consent to evaluate, but never received that permission. Then the following March, the district mailed home forms for IDA evaluation. And in this case, the independent hearing officer, so the student brought a due process complaint, the parents did. And the IHO said that from September to March, the district violated child fine, and the school had to reimburse parents for that residential program for 6 months. So initially, the early 2013, the school might not have been on notice at that time that the student might be eligible for special ed, but come September through the March, when the student was put in multiple inpatient residential programs, was self-harming, at that point they were put on notice and should have evaluated. And then A Charlie Brown Christmas is number 5, and I have seen that, and that is a good one.
One of my favorites. Yeah. Okay. So it's probably not really like any presentation, a legal presentation with attorneys, unless an attorney says something about, or something like, we always hear courts say, if it's not documented, it didn't happen. Well, here you go. This is the slide for that. This is the slide that is the reminder for districts to always make a copy of what is sent home to parents, right? And this is kind of a sad case, because where the district, was trying to get the parents to consent to an evaluation, the parents were non-responsive. The problem was the district wasn't able to generate documentation to prove that it actually made those efforts to get the parents' consent. I guess there was a cover letter that was unsigned, but there wasn't actually kind of the cover letter that was signed and actually sent home. And so, unfortunately, it didn't go well for the district. But I think, we put this in here really is just kind of the reminder to make sure that all efforts to find a child and to communicate with the parent about an evaluation are documented really well. And then the next slide really kind of reiterates something that I said before about making sure that students who are gifted may be eligible too, and are often kind of the students who sort of slip through the cracks, right? Sort of the red flags that are sometimes missed. And in 2013, and then also in 2015, OSEP issued guidance to state directors, essentially saying this: look, pay attention to the gifted students, because they may be children with disabilities who need to be evaluated too. Maybe with some kind of an emotional issue, or something, maybe a hidden disability, something that's not immediately apparent. And so this is really the reminder for that too. That just because a student may be doing well academically doesn't mean they may not qualify for a 504 plan or an IEP. absent students, this is another, we've got several slides here on this, because this is another area where, we see a lot of lawsuits, right? If a student, is not coming to school, it's really important to ask why the student is not coming to school and to find out sort of whether or not it's related to some kind of a disability or some kind of medical condition that might qualify under either 504 or IDEA. In this instance, the student had more than 25 days of absence, was at risk of losing course credit. There was a district policy that required attendance in order to receive credit in a class. The district was unwilling to make an exception to that policy. And so the district said, there could be a 504 plan for the student because the student had celiac disease, but was unwilling to make an exemption from that attendance policy. So, even though the district was willing to provide some accommodations, some home instruction, et cetera, the student still was going to lose credit. And so, that's an instance where the OCR found a violation of 504 because the OCR found that there really needed to be some kind of an exemption from a policy requirement, and this was that. And here's, and we kind of lay out the next several slides, kind of identify some sequence of facts, right, that will kind of help see circumstances where courts have found a violation of child find related to absences, right? In this 2014 case from California, it was a student with a lot of absences. The parents said the absences were due to anxiety, disturbed sleep, and school refusal. And the school knew that the student had a private therapist and a doctor, right? So this kind of series of facts, and this is really distilled right to the basics, but I think these are really the salient facts. And in this instance, the court found that there was a violation of child find. So we'll look at the next one. And this is a St. Louis 2020 case. And there was a child find violation here too, where there was a history of disruptive behaviors. There were lots of suspensions, poor academic performance. The grandparent provided a private evaluation, and the school was going to evaluate, right? Which I think was the right decision, right? That we needed to evaluate. However, the problem here is there was a 4-month delay. And so when you add up the fact that you've got these behaviors in school, we've got the negative impact on academic performance, and we've got evidence of some kind of an outside evaluation, those 3 facts suggest that there needs to be an evaluation and the school needs to really jump on it quickly. And then here's a 2021 case from Colorado where the court found that there was not a child find violation. And in this instance, the parent told the school that there were some problems at home. Apparently the student was transitioning from an old school to a new school and had some social issues associated with that. The school did do a welfare check the student's freshman year, and the student had good academic performance. And so the school had not, the child find duty, the reason to suspect a disability was not triggered up until that point. However, the student then made a threat to shoot up the school. And the court said at that point, well, the good news is the school at that point decided to do an evaluation, and the court found that there wasn't a child find violation because that was the triggering point, right? That was the time that the school obligation began. Number 4, the nightmare before Christmas. So we're getting closer to the number 1. Oh, and number 3 right here, A Christmas Carol, 1938. This is the fun one too. I like this one. All right, Caroline, back to you.
All right, so I'm going to talk a bit about what if parents interfere with the district's child find obligation. So what if parents won't consent to an evaluation? So the district has to obtain informed consent before conducting an evaluation. If the district cannot just conduct an evaluation without that parent permission. So we want to make sure, like Amy said earlier, that we're documenting all attempts to obtain parental consent for an evaluation. That if we're asking 1 month and not hearing back, we're asking again and again, and we're documenting all of those attempts. We don't need consent to observe the student and continue reviewing data and continue an intervention process. But we essentially want to meet with the parent and explain our child find obligation. If we can move to the next slide, Amanda. We want to meet with the parent, thank you, to explain our child find obligation, the evaluation process, including the assessments that will be used. We can explain that, parent can refuse to provide consent for the evaluation or after eligibility to decline services. So just because they're consenting to an evaluation doesn't mean they're consenting to the services. And then we want to make sure we're providing notice of the procedural safeguards that we talked about earlier. We want to make sure that these offers are in writing. Sometimes parents might say, I just want to bring in my private speech therapist and provide those services at school. Well, if the children require speech services at school, then the parent needs to consent to an initial assessment, and the district can then make an offer or not based on the assessment results. So we want to make sure that we're maintaining control over the individuals providing the services, and that if we're given information that alerts us that a student might be eligible for special education or related services, that we're acting on that information. And then moving on to some practical tips. So we want to make sure we're considering all the information about the child. So we talked about other sources of data. Of course, the state assessment results, grades, private evaluations. We talked about absences and tardies. If we have knowledge of outside private diagnoses, what we're observing in the classroom. And then we want to make that referral for an evaluation within a reasonable time period after suspecting a disability. So we want to keep in mind the total time that the student has struggled academically or behaviorally, and if circumstances has changed since the last time we thought about whether the student needed an evaluation or had an evaluation and was found ineligible. The severity of the student's difficulties, and then knowledge of other factors, like if the student is self-harming or being placed in, a mental health placement, or any concerns with mental health, really, and keep all of those factors in mind. And then number 2 is A Christmas Story, which is a great one, and we watch every year. And then Amy's going to wrap us up with some big picture takeaways.
Yep, we watched that one several times at our house every year. So the big picture takeaways, one regarding child find, make sure that you're familiar with your district's policies and procedures on child find. Sometimes, ironically, sort of the child find policy can be hard to find, but it's there. It should be there, and so make sure you should know about that. Make sure, as we mentioned a couple times, that sort of efforts to identify a child or efforts to talk with the parent about doing an evaluation are well documented. Develop good relationships with the private schools in the district, right? Because the school district's obligation to child find extends obviously to the students who are enrolled in the district, but also to any students who live in the attendance area, regardless of whether or not they are attending the public school. So even if they're attending the private school or if they're homeschooled, there's an obligation to make sure that those students are evaluated too. And that gets to kind of the publication. How are we publishing those policies and making private districts, private schools and others know about sort of the evaluations that will be offered to the public school. Don't let a parent's reluctance to evaluate deter an evaluation. While you have to have consent, right, to do sort of an evaluation for IDEA, there are certainly other things that can be done, other supports that can be provided, and it's really important to make sure that because sometimes parents will change their mind. And so, at one point they may say, no, I don't want my child evaluated. And then, who knows, 6 months later, they may say, the school should have evaluated my child 6 months ago. And it's tough then to be able to say, well, we wanted to, but you wouldn't let us. And so you want to make sure that you're continuing to press on parents. If you're in a situation where you believe a child really might have a disability, you want to make sure that you're sort of exhausting all of the avenues that are available to you. Number 5, again, because it's so important, don't let a parent's reluctance to evaluate deter an evaluation. The child find duty under 504 will be triggered more easily than the duty under IDEA because the definition of disability is broader, right? I touched briefly on the fact that a child is eligible under IDEA if the child fits in one of the 13 eligibility categories and there's this adverse impact on educational, academic performance, or functional performance. That's the standard for IDEA. The standard under Section 504 is much broader. Any kind of a medical condition that impacts major life functioning. So that's really broad. The OCR is likely to find the obligation is triggered even if there isn't any kind of an adverse impact on academic functioning. So that's just something to make sure that you note. And so our general advice is when in doubt, evaluate or ask the parent to consent to an evaluation. You can, after you gather the data from an evaluation, it doesn't always mean that the child is eligible, but at least you'll have the benefit of that data. You used to be able to show if the parent, says, look, the later alleged that there was a child find violation, you'll be able to show that you did evaluate. So, and remember that if you choose not to evaluate, it's important to communicate with the parent in writing about all those reasons for not evaluating. So talking about kind of why the student is doing well, why there's not an impact on either academics or their functioning or behavior. So, and making sure that we're also providing procedural safeguards under IDEA and 504, frankly, at that time. And I think that, yes, that leads us to the number 1. I know, go figure. It's a wonderful life. So definitely a well-deserved spot at number 1, I think. So what questions do you all have? How can we be helpful? Well, we're happy to stay on for a bit. Thank you so much for having us.
Thank you both so much. Great information. Loved the holiday movie twist. And some of them I'd never seen before, so that was kind of interesting. But definitely love some of them on the list. But thank you both for being here. We will stay on just for a minute. If anybody wants to add to the chat a question, or if you want to unmute and ask a question, that's certainly fine too. And as we kind of wait to see if there are any questions, I'll kind of close out our session, letting you know that our next Spotlight on Legal session is actually January 29th. And we will be talking about educational records and counseling notes. Registration is live for that. So you can just click on the slide here to find that. And registration for the March session is also open, and that will be on bullying and abuse reporting. So make sure to join us for those. Here are just some resources I like to include. One of them on the far right is the calendar of events. This isn't just Counselor Connect events, but it's any event, any important date for counselors and social workers. So be sure to check that out. If you would like a PGP point for license renewal for attending today's session, you can just click on this very short evaluation, fill out that evaluation, and then you will automatically receive that PGP point in your email inbox within a very short period of time. And finally, a lot of our upcoming events. This is really our last one, I think, in December, but we have several scheduled for January and February. So check all of these out. One of them a couple I will highlight actually. Coffee Talk in January, Flora Jones is going to be giving us an update on the diploma redesign. So you don't want to miss that, especially if you are a high school or middle school counselor. And then we are doing our annual winter book study starting January 29th, and we are reading The Anxious Generation this year. So really excited to dive into that book and talk a little bit about it with our friends and colleagues. So hopefully you can join us for that. With that, here's some contact info, and I'm going to see in the chat, do we have any questions? It doesn't look like it. Somebody said they can't access the links. Let me send you this slide deck. Make sure you have this one, because I may have sent you the other slide deck. Okay, so in the chat is this slide, the slides that I'm sharing now, and you should be able to just click on the graphics for any of those upcoming events, and it will take you to the registration page. Okay, thank you so much. I hope everyone has a wonderful holiday. Thanks for joining us. Take care. Thank you, Amy and Caroline. Amazing information. Really appreciate you both. Thank you.